Okay, hey, welcome to another edition of the Trustcast Show, and I'm really delighted to have Reed Morgan on with me. And he spent 48 years as a trial lawyer taking on big companies like Exxon Mobil and actually winning. And he's a staff member at Gerry Spence's Trial Lawyers College and board certified in personal injury trial law. And now he's launched Victory Alliance Partners Consulting to teach trial lawyers how to communicate in ways jurors actually understand. So here's my opening question. After 48 years of trying cases, you said verdicts aren't decided by the facts, they're decided by how jurors understand the case. Maybe you can just take off with that right. When did that actually hit you? At what point in your career did that actually that thought?
Well, that's a very good question, Zane, and I'll answer that in this way. For years and years, I was trying cases without any trial lawyer training. I didn't take trial advocacy when I went to law school. And so it was a self-learning process, trial and error, trying to figure out why certain lawyers are winning consistently and why others are not. What is it about it? Is it an innate genius to be able to do so, or do you need to be trained? And then I went through Gerry Spence's college back in '98, and I'm no longer on the staff over there, but it's an excellent institution. And he brought to the forefront the human element that comes into decision-making processes. And from that, I've spent the past 20 plus years studying the psychology of persuasion, how to talk to a jury in a way that they reach the opinion themselves of what to do with the case. We don't tell them what to do. We don't attempt to tell them what to do. You can watch 48 Hours or any of those shows about criminal murder trials, and you're going to see the lawyers, the defense lawyers, repeatedly always telling the jury, this is what happened and this is what you must do. What I have learned to do is tell a narrative, cohesive story that makes sense, develop in the listener's vernacular and their feelings in their heart. Where are the parallel stories in their life? How do we touch what their belief system is? And from that, they develop a feeling of whether there's been a moral wrong done or not. And that's where the winning comes from, is reaching them at a very deep level of understanding. You have to have, of course, as a lawyer, credibility and trustworthiness. And from that, they come to their conclusion. How do you do that? That's what we teach, starting from voir dire, opening statement, direct examination, cross-examination, and of course, closing argument. And putting the pieces together with the evidence sequence properly and indexing it to the applicable law. So that's the basic methodology. And it's an important question because what I found myself doing for years was, how are we going to start where we grab the jury's attention immediately? And you're not going to do it with a stack of facts. You're going to have to touch them at some deep level of understanding from their own experience.
So it's when I listen to you, kind of describing it, it's interesting the uh, the parallels between writing good copy, which I have personally been involved in for decades,
Yes, sir.
and it was all about telling a story,
Right.
and you have to hook somebody in the front end, and the description that you gave to me kind of really resonated in that idea that you need to get someone um, emotionally engaged immediately. Was that accurate?
Absolutely. It's there's been a lot written about the empathy molecule by Zach and others, and I guess the easiest way to describe it is when you develop a friendship, male or female, spouse or good buddy, you're not interested in what clubs he belongs to, how much money he has, what kind of car he drives. You want to know what kind of human being he is. And over the years that I've been a plaintiff's lawyer, one of the things that has resonated with me repeatedly is we must be truth tellers. Our witnesses and our client must be truth tellers because they have their story. And their story always is you caused your own injury, or if you're injured, you're not injured as badly as you say you are. And so, how are you going to overcome that? You're going to overcome it with the truth and with life's experiences that people resonate within themselves. And if you don't have that in the case, then you shouldn't be in the courtroom in the first place.
So how do you interweave that together with that, with the law, the the overarching law or is that less important than the story itself?
Well, the law, the way we're taught in law school is you have to have duty, breach of duty, causal connection to whatever you're complaining about, and then your damages. So you do have to know to do that so that the judge doesn't direct a verdict against you. And I think that if you are able to frame the law in such a way that the jury appreciates, I like that law. I think that we should all follow that law. That's a morally correct, paradigm of the world, and I like it. I've done that in jury selection in a medical malpractice case, for example, asking the jury, how do you feel about having the right to sue a doctor if he's done something that's really caused a lot of harm, not because he made a mistake, but because of some other reasons. Maybe he was in a hurry, to do something or whatever. And so, yeah, you've got to use the law, of course, but that's not going to be any more than just the stack of facts the way to win a case.
Mm-hmm. So you won an $8 million verdict against Exxon Mobil for a worker with kidney cancer. Is that right? What was that trial like?
That trial was out in San Francisco. It was a seaman that came to me, Mr. Gregory, and he had a very unusual situation. He had developed hematuria when he had his annual blood test or examination. It wasn't a blood test, it was an examination by their physician. And it showed that he had blood in his urine called hematuria. And he was marked fit for duty to go back to work. And after about a year, it turned out that he had kidney cancer. 20% of people with blood in their urine have kidney cancer. And so, the position of the defendant was, we didn't cause this cancer. We weren't concerned about causation, even though later through epidemiology and studies by physicians, peer-reviewed groups have associated kidney cancer and bladder cancer with exposure to benzene. And I misspoke. It was a bladder cancer, not a kidney cancer.
Okay.
In any event, we went to trial, and of course, the jury, the case we put on was the physician that gave him this examination didn't explain what he had. The report was marked hematuria bears watching. What does that mean to a seaman that's working to earn a living on a vessel? Nothing. And so there was no warning, and it expanded and ultimately took his life about 2 years after trial. But that was a prime example of putting the jury in the shoes of the plaintiff in closing argument. If you were in charge of safety on ocean-going vessels in your office, and the Coast Guard explained to you that they wanted to come test and determine if you had excess levels of benzene, would you take those test results and shove them in a filing cabinet, hide them from the workers? And essentially, if you gave them a physical exam, would you not explain to them that the results meant you've got to get re-examined and treated before you go back to work?
So if I understand this right, you were probably through discovery, but you probably this was a doctor who was directed by the company to do this exam, and then they had the results, and it wasn't explained to the employee,
Right.
and that
He
was
was actually an employee of the company, the doctor.
oh, okay, yeah,
Yeah.
boy, that changes things
Yes.
dramatically. Yeah,
Right.
that's very sad. So I've talked to different attorneys about vicarious trauma. Um, how does something like that emotionally affect you? Defending that situation, had he already passed by the time the jury, it was really his family that was bringing the action? No.
No, he was very much alive when we tried that case, and his treating doctor had estimated that he had 4 to 5 years to live, and neither he nor I really believed that he was going to lose his life over it, but he did about 2 years later. Very sad. How does it affect me? It's very heart wrenching because one of the reasons that uh, lawyers like myself do this is to help people that can't help themselves. There's no way they can explain a case like this, and if we don't do it right, it's their last stop. And you develop a deep friendship and understanding about these types of persons that have worked hard, and fallen ill through no fault of their own. And the older you get, it seems like the more heart wrenching it gets. The more life's experiences that we have.
Yeah. So did you ever go up against Exxon's legal team on any other occasion?
Oh yeah, yeah, I
Oh
have.
yeah, more than
Yeah,
and
yeah.
do you want
Actually,
anything you want to talk about in
actually,
particular that
yeah. Actually, come back to thinking about this. The case that you started this conversation with, it was an $8.2 million verdict, and it was for it was a kidney cancer case, but the other one was so similar. It was a bladder cancer case, and yeah, we took that to trial and won it as well. I'm a little convinced that it's not so much that you get a verdict, as it is that you right or wrong. Seriously, I mean, I see so much going on in the legal system now where people are bragging about their big verdicts and all that. That's not where I'm coming from. I think the most important thing is when somebody really needs help, that you develop a skill level where you can walk away from an unreasonably low settlement offer. And and if I could communicate one thing that I would really like to be able to do is help lawyers jump over the meritless defense that your client doesn't deserve to be compensated.
so explain to me what you mean by that.
Well, I don't think it's any secret to you, Zane, or to anybody that's in the practice of law that when you file a lawsuit, um, it's been my understanding and experience, that the other side very rarely comes to you with an agreement to pay the claim before they get into discovery. And once they get into discovery, it seems like you're getting into more and more wrapped around the axle of are you going to be able to prove your case against our defenses? And the defenses are often um, meritless defenses, but they might be believed if all you're going to do is argue the facts. You're going to have to show what kind of person you represent, where they came from, what they did with their life, and why, being a truthful person, they didn't make this up. This happened. I've had cases, for example, where a young man was working in a chemical factory that made utility computer boards for phones and laptops. And the chemicals cause myelodysplastic syndrome, cancer. he had been out of that plant now 25 years, so the evidence is pretty well gone about the quantity and all of that. So they absolutely didn't want to pay a penny.
Right.
But by developing the peer-reviewed literature that showed that the products that they had out there contained cancer-causing agents, finding just one really good, truthful coworker that could describe how this material was dripping through the grating over his head, through the ceiling, onto their bodies, going back 25 years ago, we were able to hook it up and connect it and get that case settled. But what I mean is it's really, really a fight in these types of cases.
And you were just talking about how unreasonable defenses can end up. I think what was the phrase that you used for talking about defenses that were not
well,
smoke screens, almost, for example.
I'll give you an example of I had another case. I don't want to keep talking about corporate names, but it was an oil company, and the fella came down with acute myelogenous leukemia, which is they call it the signature cancer for exposure to benzene. And this fellow worked on an oil tanker that carried gasoline, which is full of benzene. And so he files the claim without a lawyer, and he gets a letter from the oil company that says, "You must have gotten this disease somewhere else." And we're off.
And how long had he worked at the oil company?
Oh gosh, at least 20 years. I mean, it was yeah. So it's a sad situation. It really is. It's a very sad, frustrating situation. And I must say that it's not always not only the defense that's fighting you, but the judge is fighting you. We've got some wonderful judges in this country, but we also have some that are very, very unwilling to accept a fair fight. Let me put it that way. Very frustrating, tremendously frustrating. I mean, you can work for years on a case and have it taken away by, a jurist that doesn't want to follow the law.
And when that happens, then your only alternative is to somehow find some cause for an appeal. But that's a whole different animal, isn't it?
That's a tough row to hoe, because you're going to file your papers, and you're going to get an oral hearing in most jurisdictions, and you're going to have 15 to 17 minutes to argue a complex case. And you don't know, did the law clerks read your papers, your brief? Did the judge? Is the law clerk looking for a job with a major law firm in the same city? How's that going to go down? Yeah.
So the whole it has a whole different complexion to it. So let me ask you just a little bit about your time at Gerry, Spence, and I want to make sure that we get back to your new venture, because I'm interested about that.
Right.
So how did you end up at Gerry Spence's? Is it Gary or Gerry?
Gerry. Gerry Spence is amongst the best lawyers that ever walked the earth. He passed away within the past year, but he went something like 55 years without ever losing a civil case.
Wow.
Yeah, he has a website still. I believe it has a lot of his accolades, and he's published at least 15 or 20 books. But I applied to the Spence Trial Lawyers College because I realized my own inadequacies of being able to do the things I've been talking about today. And fortunately was admitted back then. It was a 1-month curriculum where you actually spent a month out at his college in Du Bois, Wyoming. And you learn a lot of methods to connect with people on a deep level.
So you went from student there to staff. How did that all take place?
I was on the staff a brief period of time there, and they have really good, intense training programs. They have the long course. I don't know how long it is now, but they have weekend courses as well. And I would highly recommend, that anybody that wants to learn how to be a really good trial lawyer go there. They don't accept defense lawyers, civil defense lawyers. Yeah, they accept criminal defense lawyers and lawyers for people. Yeah.
So here, I got a bunch of, I'll have just for fun, I don't know if it's fun or not, I'll have a bunch of rapid fire questions and then I want to get
Yeah.
into Victory Alliance. So biggest verdict you can talk about.
I would say probably the verdicts that I've gotten for the cancer cases, the chemical or oil exposure cases. We had one that was 10 million. It was kind of an interesting proposition. After the trial, I talked to the jury, and they said you should have asked for 20 million. So, lesson learned.
Longest trial you've ever done?
Let's see. Oh goodness, going back years ago, I had a case in downtown Houston against a lot of oil companies. I can't remember the precise number, but probably about 15 of them for exposing landowners in Mont Belvieu to a lot of hydrocarbons that were underground coming up in their yard, things like that. And that was about a 6-week trial.
And in court, suit or no suit? No suit. And how did that change over the years, or did it?
What do you mean, no suit?
Do you wear a suit or not wear a suit? These are just
yes.
rapid fire fun questions.
Yeah. I mean, in federal court, you're going to wear a suit. In state court, you can wear a sport coat, but you're always going to have on a coat and tie.
Morning
Absolutely.
prep or night before prep?
I prefer morning prep. Go to bed early, get a good night's rest during trial, and get up early.
Yeah. Best cross-examination you ever did?
Oh, gosh. I had a case one time where a man who was actually the brother of a good friend of mine had a heart attack and died at a training facility for self-defense. And it turned out that the equipment that was there to try to save somebody wasn't put to use. And when I took the deposition of the person in charge concerning whether or not the forgery on the release that had been signed was done after his death, and he took the Fifth Amendment, and several times in the case settled after that, if you can imagine.
Yeah. Coffee or bourbon after a verdict?
I would definitely at least go with the beer.
Okay. What do you think most lawyers get wrong about juries?
I think they categorize them. There's a lot written about sort of a pigeonhole you put people in based on their profession. And it's been my experience that everybody's human and has human emotions, and that's what you really want to find out, is whether the people that you're taking a voir dire from are empathetic and understand that you're there for a purpose. This is not a billboard type case where you're just in there for a quick buck. There's somebody's life and family that's been impacted.
So you talk about anchoring jurors early. Can you explain what that means?
Well, anchoring, of course, if you want to solidify somebody's concept of your case, you're not going to do that in voir dire because you can't get into the facts of the case. You can certainly get there very early in your opening statement if you have created um, enough trustworthiness in voir dire and credibility that they now know that you're not there seeking something that is frivolous or unjust, that you've got a good case. And then you can anchor them by exposing the problem, the principal core problem in the case immediately, and work from there so that the theme of the case is very obvious from the get-go.
So is that something, that's something you do in an opening statement? And what do you think the biggest mistake that lawyers will make in their opening statements?
Beating around the bush, not getting to the point, not making it very clear to the jury what it is you're complaining about and why, and using juxtaposition to show what could have happened but didn't happen, and explaining why that should have happened.
Okay, so I want to get back to talking about Victory Alliance partners. So you've had all these experiences, great experiences, and these fabulous cases that you've helped people with, and now you're supposed to ride off into the sunset and enjoy your retirement. Now you're starting something totally new. I mean, I'm a big supporter in doing things late in life anyway, but some people probably think you're crazy. So can you talk about the passion now at this point in your life?
I think the passion comes from knowing the angst that a lot of lawyers go through, probably particularly younger and mid-level lawyers. There's great lawyers out there that know a lot of what we do, but the angst of not knowing I can win this case because I have the toolbox and I have the know-how of how to present this and to present it in an honest, truthful way. There's no tricks here. I don't have to go to a seminar and see how somebody else does it because I know how to do it, and I know that if I take these steps, I'm going to reach a jury, and they're going to understand my case and they're going to believe in it. And so that drove me to thinking, after all the years of learning and struggling with how to try cases, why would I want to foreclose that to the community? If I can help people, then wonderful. Let's do it.
So tell me the process of your Victory Alliance partners, and what do you do, and how do people find you? And so if someone comes to you and says, "Oh, I want your help," what do you do for them? How do you help them?
Well, the easiest way to find this, first of all, is victoryalliancepartnersconsulting.com, vapartnersconsulting.com. What do? We ask them, first of all, what do you feel you need help with? It may be the entire case, it may be voir dire, opening statement, sequencing the proof, formulating the story, which is absolutely critical. Those are the things that we feel we're very good at. And focus groups. We have an alliance with a company that does focus groups through the internet where we can get a statistically significant group of people, like 150 to 175 people, looking at a neutral presentation of the case. We're not there to win the case. We're there to present what we believe we can present, what the defense can present, and then get an adequate and accurate portrayal of where the issues are and what are the drivers in decision making. And if we miss the mark, then we have to go back and redesign the case. If not, we can walk into the courtroom with a statistically significant knowledge that number of people from the community where the case is going to be tried looked at this case neutrally and made a certain determination, which is fantastic. I mean, 10, 15 years ago, we couldn't do that.
Yeah. So if someone has this case and they're not really confident in, there's a bunch of questions in their mind. How am I going to defend this? How am I going to, or how am I going to, advance the cause of my plaintiff, of the plaintiff? Then you can come in and add a different perspective to the way that they might proceed. Is that kind of an accurate description?
Absolutely. I mean, ordinarily, if they're going to do a focus group, we would participate with them and read their, at least read their deposition of the plaintiff and look at their pleadings and talk to them deeply about the case and formulate the story of the case neutrally and then have it presented. Um, and a lot of lawyers do this. Most defense firms, civil defense firms, do focus groups all the time. We believe ours are better because they're more statistically reliable. There's no sense in doing a focus group if you just want to get the result that you want, pat yourself on the back, because you're not learning anything.
Mm-hmm.
You know.
So you're looking for a totally neutral result because that way you can see, are you heading in the right direction. So let's say you get down the pike a ways and you have somebody who's whatever, a younger lawyer, maybe a mid-experienced lawyer, and he's convinced about the way that he's going to go, and then you come in and you say, okay, that sounds logical, and then you do the focus group and the research, and it comes back, no, we don't have an advantage in this presentation. Then where do you go from there?
Well, we probably would not use his presentation model to begin with.
Okay.
Because we have techniques that we're very good at in telling a story quickly and getting the theme of the case out there quickly. But to be honest,
I need you on my copywriting team.
I have seen so many experienced lawyers, really experienced, top level, top flight lawyers. We tried a case 2 years ago against one, and they're terrible. They are absolutely terrible. They do not understand how people make decisions. They don't understand credibility. They don't understand jury selection. You don't leave rape victims and gay people on a jury when the case is about sexual harassment. You just don't do that, because those people have a deep parallel story of deep, deep hurt that's hardwired in their brain, and they're dripping with empathy, and you don't accuse the victim of gilding the lily because you don't understand that they're so humiliated and embarrassed by what happened to them that every day of their life has been affected, and they're standing there belittling that person. So, yeah, I really feel that if you don't understand humanity as a plaintiff's lawyer, then you've got a big problem. And same thing is true for the defendants.
So so you come in and you help them analyze what it is or where they're going, and present the idea on how to proceed forward. And what percentage of the clients say, you know what, Mr. Morgan, I mean, your clients are lawyers, or do you just feel like you make such a logical case as to why they want to do it this way? They've already paid you, that you've got the experience. Do you ever get pushback?
I don't get pushback. And the reason is that they come to us because they need help and they know they need help. They don't come to us because they just want to see somebody else's game plan.
Mm-hmm.
And they're good, honest people with the desire to do right by a client, and they'll listen and they'll learn.
What do you do in focus groups that most lawyers skip?
Well, for one thing, the statistically significant number of people. If you were going to do a focus group in a conference room, call in 160 or 175 people, you're going to have a much huger expense than if you do it by the internet. The second thing is we make sure that we have unbiased jurors by the way that they're selected between conservative, middle of the road, and liberals. You don't want to stack it with your types of personalities or leanings. So that's different. And then the last thing is we look very carefully at what are the drivers of the decision making. What really is the point where the jurors say, I can't get over the fact that this happened or that happened. And that makes for a compelling reason why I'm voting the way I am.
So what part part does juror selection play in your overall process?
Huge. That's where you make the connection with credibility. And the way we do it, we don't try to deselect people. We want fair, even-handed people. And the best way to do that is tell them that. If you read our voir dires, we literally explain to the jury, we want an even playing field. If you're leaning towards the defense, then you need to tell us that. If you're leaning towards the plaintiff, you need to tell us that. Because otherwise, the parties have spent hundreds of hours preparing a case, thousands of dollars of preparation, and the game's not going to be fair because there's basically a ringer in there that regardless of your position, they're just against your case. Maybe they don't believe in personal injury lawsuits. Maybe they don't believe in discrimination cases. Who knows?
Mm-hmm.
Got to ask.
So so we've already got your website, we've got your contact information. What final thing do you want to leave with our audience if they're a law firm out there and they have a case, they're kind of unsure about what to do, what would you tell them?
I would tell them that if they feel like they need assistance in understanding how to get the truth to the jury, to overcome any defenses that have been put up against them, that they're worried about the defense. They've probably been told time and again, you can't win this case, your plaintiff is at fault. We have methods to show that the plaintiff is not at fault. And it goes to the heart of the theme of the case of where's the problem? What's the backstory? What's the meta story? Where's the greed? Where is the choice that was made that was wrong that led to this disaster? It didn't start with the plaintiff on X date. It was there for a long time. So
how long do you want to continue doing this? Till you're gone?
As long as I can still help people and have fun at it, sure.
Okay,
yeah.
That's good.
I like to work. I don't want to sit back.
So I'm with you there. My wife says I'm crazy. So I'm experienced in life, and I had a long career. And then she says, "Well, let's go retire and let's go do this or that." And
right.
I